Hi, Dina. Great to see you.
Oh, really?
It's okay.
That one, 6 copies.
Yes, please. Okay. So we speak into that. And they have something too.
Their microphone's in the middle there.
Okay. Just a couple housekeeping things. We are taping the entire thing by Zoom, and then we have a court reporter who will create a transcript from that. All the in-person court reporters were taken, so it's been pretty crazy with that. But I just wanted to let you guys know about that kind of official aspect. I'm going to pull the board agenda up for board president, and then I am going to recommend we go into executive session to start so that we can get our bearings. We've got a couple brand new board members, as many of you know, and then we'll come back in and get started. Suzette, do you have internet connection right now?
I've been waiting to get online. I'm not sure if I do have
This.
this.
Hotspot. I'll do a hotspot.
I do
Oh, you do?
have
Perfect.
this if you want to look at that. And then these are the documents. And these are what I printed out by myself.
Okay, so that's not the agenda.
That's not the agenda, but let me see if I can get on.
Yes, sir.
says it is.
Yes.
Call to order the special school board meeting to conduct a discharge hearing Tuesday, February 15th, 2022 at 1:11 p.m. Shiprock Boardroom, Shiprock, New Mexico. So as to comply with the governor's social distancing orders and consistent with guidelines from the state attorney general's, this event will only be available to the public via live stream on the Central Consolidated School District YouTube channel. This meeting is closed to in-person public participation. Roll call. Mr. Montoya?
Here.
Ms. George?
Here.
Ms. Askey?
Here.
Myself, we have a quorum. We'll now adjourn to executive session. Conducting discharge hearing in open session as elected by employee and convene in and out of executive session as needed. Convene in and out of executive session as needed to discuss limited personnel matters regarding discharge hearing before the board and to protect confidential personnel and student information as may be disclosed during the discharge hearing as permitted under NMSA 1978, Section 10-15-1 H2 of the New Mexico Open Meetings Act. I need a motion for adjourn to executive session. Do we have a second? It's been moved and seconded that we go into executive session. Gary Montoya? What say you? Miss George? Miss Askey? Yes. And myself, yes.
Am I correct?
Yes.
Yes.
3 whole weeks. I mean, that's it.
I need a motion and a second to reconvene in open session. Only the items discussed previously regarding executive session were discussed in executive session.
I make the motion to reconvene.
Do I have a second? Mr. Ms. George? Saski?
Yes.
And myself, yes. I need a motion and a second to appoint General Counsel Jermaine Chappelle as hearing examiner to advise us on procedural matters for this hearing. I have a motion.
I'll make the motion.
Do I have a second to that? Mr. Montoya?
Yes.
Ms. George? Ms. Haskey?
Yes.
Myself.
Good afternoon. Parties, can you hear me all right? I'd like to get started on making appearances first, and then we've got a procedural matter we need to discuss. Who'd like to go first?
Members of the board, Dina Holcomb on behalf of the Central Consolidated School District Administration, and with me at council table is Daniel Benavides and Cheryl McNellis.
For the appellant, I'm Greg Maxey with NEA New Mexico with co-counsel Eva Krakowska. Good afternoon, board president, members of the board and council. Also seated with us is the appellant, Dr. James Marcia.
Thank you. The next, concerning date pursuant to statute, in order for an appeal to be valid, that must be filed within 10 days. The timeline that I project for that, those are calendar days, and it did fall on Thanksgiving, so the day after that is the 26th of November. And notice that I believe you have marked as Exhibit I for the appellant indicates notice of appeal was filed December 30th, 2021. Is that correct?
Madam Board President, members of the board, council, it is my understanding from Ms. Krakowska that stating December was actually November and was a typo. And if you look at the emails that accompanied that, they were on that date of November 30th, 2021. I don't believe that is in dispute, but at this time I yield back. Board President, members of the board, council, also the statute is clear that it's work days, not calendar days. All
I
things.
apologize.
Yeah, all
The
things.
calculation of the 26th is work days.
I would go to my colleague.
The work days are considered the days when the district office is open. The district office was closed on 24th, 25th, 26th, 27th, and 28th of November. So the day 10th is November 30th.
So Ms. Krakowska, and representatives, I do not see that in the statute, nor do I see any case law that discusses that. From my perspective, and I'm going to hear from opposing counsel as well, the language clearly states working days, and working days are used throughout the statute. I am going to get opinion from Ms. Holcomb as well on this, but if this can't be resolved, my concern is that the statutory deadline was not met.
We would strenuously object to
I
that.
understand that, but I'm going to go to Ms. Holcomb on the
Yes.
objection.
Ms. Chappelle, members of the board, we had calculated that as well. We don't dispute that their certificate of service incorrectly referred to December rather than November. We did receive it on November 30th. I did calculate the days out as working days that the district was open. I agree with you that the statute is not clear on that matter. We did not contest that it was untimely filed.
So with that, I'm going to have to, that changes obviously the information that I had, because what I understood was that it was December 30th. And so I'm going to now defer to the board on whether to proceed with the case or to potentially determine that the case was not timely filed. We've heard your objection.
Well, I would like to add to that objection. This is
I have not recognized that you can do that.
well, as the board president, this is what my concern is. This is the board president, and it's the board's hearing, and I would ask that the board president rule on whether he wants to.
Mr. Massey, you
Wait,
have not been
may I
acknowledged, and
finish? May I
you are-
finish?
you are-
May I
Mr. Massey,
finish?
this is not acceptable.
The board
No.
president has the authority.
Mr. Massey, please sit down.
You're creating the situation.
What I just said, Mr. Massey, that you are now repeating, is that it is up to the board to determine whether to proceed with this case or determine whether or not this was timely filed. I do not need to hear from you on that matter right now.
Board president, members of the board, general counsel, I was asking the board president to proceed with an additional argument that clarifies the position that Ms. Holcomb said in regards to we always use working days in which the office is open. I can opine on that, and that's what I was asking the board president if I could. Board
That issue has
president,
already been stated,
if-
Mr. Massey.
may I
You have not been
finish?
recognized.
Ma'am, may I finish?
No, you have not been recognized.
The board president has not spoken on whether he wants to recognize me or not. You were just selected by the board as their executive to advise on matters, not to rule on procedural development. This was the very thing we had expressed to you in an earlier phone call. The board president, this is the board's meeting, it is the board president and the members of the board that are allowed to make that decision once the board president was rendered as the hearing officer as you came into session.
Board, I now turn the matter over to you to determine whether you want to proceed with the case or determine if the matter was timely filed. You do have as an option to caucus in executive session if you do want to discuss that further.
Yes.
I'd like to make a motion to move into executive session for clarity on the actual rules that transpired before filing.
Do I have a second for that?
I second that.
Mr. Montoya, how vote you?
Yes.
Ms. George? Ms. Askey? My- We'll adjourn to executive session.
Testing, testing, mic check, 1, 2. Hello, you. Testing, testing, mic check, 1, 2. Testing, testing, mic check, 1, 2.
Oh, did you? I can't even turn. I guess I'm not getting my eyes.
Yeah, well, you took this one right over your, right over your breastbone here, right over your sternum, and then you should be.
I guess I thought I would hear it.
Yeah.
I was just reading.
Are we ready?
Ask them if we're back on. Are we back on, guys?
I request a motion and a second to reconvene in open session. Only the items discussed previously regarding executive session were discussed in executive session.
I make the motion. To reconvene.
Do we have a second? Mr. Montoya?
Yes.
Ms. George? Ms. Haskey?
Yes.
Myself, yes. We respectfully request the parties to abide by the hearing process and the authority granted to the hearing officer to conduct the hearing going forward. I request a motion and a second to accept the appeal as timely. Do I have a motion?
I motion.
Mr. Montoya?
Yes.
Ms. George? Ms. Haskey?
Yes.
And myself, yes.
I think the board and parties, the opinion is on the district, so I will start with the district.
Ms. Chappelle, members of the board, I do have a question regarding procedural matters.
What's your idea?
On the notice of hearing, it states that we have 2 hours for this hearing, so that I would assume then that the administration has 1 hour to present its case. Is that correct?
Yes, that is correct. Thank you
I'm
for that
going to
clarification.
actually run a timer so I can keep an eye on that and be cognizant of the board's time, as I know they also have a meeting after this. And if you don't mind it, I will sit during my presentation, if that's okay.
That's fine, thank you.
Do have a very short opening to bring the board at least some preliminary information with regard to the case that will be presented to you today. This is a case involving TVA Middle School and Mr. Marcia, who was a math teacher at the school. In particular, it was an 8th grade class that we will be addressing. He is a new teacher this year, having broken his contract last year. In fact, he walked out on the school district, giving only 2 weeks notice last school year in September, and leaving the district without the required 30 days notice. So you'll hear him repeatedly state 4 years with the district, which is incorrect. Having broken his contract last year, he is actually considered a first-year teacher with the district. But the incident that we are here for today occurred on September 1st during the last period of the day at approximately 3:04 p.m. when a student was smoking marijuana in his classroom. We'll be careful not to use any references to the student's name in this hearing. Luckily, the educational assistant was observant and noticed the student smoking the marijuana and took her to the assistant principal's office, Mr. Switch. As she was headed down the hallway, she actually encountered the principal, Dr. Pandora Mike, in the hallway and informed her what she had just observed. Dr. Mike confirmed the incident with two other students in the classroom who were sitting next to the student, had observed the marijuana being smoked during class, and had also observed the student place the drug paraphernalia in a bucket. Dr. Mike entered the classroom and retrieved the drug paraphernalia and went back to Mr. Switch's office. The law enforcement and the parent was called as appropriate. This is an incident in which Mr. Marcia took no action whatsoever. He didn't take any action on the student. He didn't take any action to retrieve the drug paraphernalia, and he took no accountability following this incident. He didn't accept any responsibility for not being observant of the students and supervising them in his classroom. He didn't take any responsibility for not retrieving the drug paraphernalia. He never sought on how he could improve this situation in his classroom. He never offered or asked for any ways in which he could help solve the problem. In fact, what he did, and what you'll probably hear today, is further blame other people. He blamed the principal, telling her it was her job to supervise his class and take care of the drug problem. He blames administration. In fact, he goes so far as to blame this community for its drug problem. That is why we are here today, is simply because he refuses to take responsibility, take direction, and follow the safety protocols, this board's policies, and the state law. And so we're going to ask that you uphold the recommendation for his discharge. And with that, I'd like to call my first witness, which will be Dr. Pandora Mike. Would you like me to bring her in here to speak? And Ms. Chappelle, will the witnesses be sworn?
Yes. Ms. Pandora Mike, can you please raise your hand? Ms. Pandora Mike, or Dr. I apologize, Mike, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. I'll leave it to you to present your witness.
Thank you. Dr. Mike, would you please state your full name for the record?
Pandora, Mike,
And what is your title with Central Consolidated Schools?
I'm Secretary of School.
And can you tell me how long you've been the principal there?
I started there July 2021, so a little less than a year.
You may need to use that microphone. And how many years have you actually been with Central Schools?
I started in 1983, so almost 29 years.
Do you hold any special status pertaining to your principal position?
I participated, I got accepted into through a program called the Principles Pursuing Excellence Program. It's a rigorous two-year program with the Public Education Department.
And can you tell me how you first became aware of an incident involving Mr. Marcia on September 1st, 2021?
I was in the hallway, walking in the hallway, and an educational assistant approached me and told me that a student got caught smoking, and she was walking the student to the classroom. So I asked her which classroom, and she directed me to that Mr. Marcella's classroom.
And what did you do when you got to the classroom?
I turned on the lights, and I asked her to show if there were any other students and where, and so she pointed to other students, and I told her to go ahead and walk the student to the office to be interviewed by Mr. Switch. So I talked to the two students, I had them come out and talk to them, and they confirmed smoking marijuana in the classroom.
That the one student had that was taken to the office?
Yes, the one student that was taken to the office, correct.
Did they also point to where the drug paraphernalia was?
Yes, they pointed to a bucket that was located in the classroom where, then I retrieved the paraphernalia and marijuana.
Was anyone contacted about this incident?
The parent of the student and the law enforcement were contacted.
And did you talk to Mr. Marcia that day?
Just when I went in there, I told him to leave the light on and that I would need to talk to him about the incident after class, because it was almost at the end of the day.
And did he actually come to talk to you after class?
I didn't get to talk to him until the next morning because the incident occurred just after seventh period had started, and we were still dealing with the law enforcement and the parent.
When you met with Mr. Marcia on the next day, September 2nd, did you discuss the incident?
Yes, Mr. Switch was present in my office, and I did. I wanted to talk to him about some safety protocols that were not being followed, with not entering the front door to get a temperature check consistently, and not wearing his safety vest, not carrying his emergency go kit when we had emergency drills. And yes, I did want to talk to him about the incident that occurred.
And what was his demeanor and response during the meeting?
Mr. Marcelo became very defensive. He did not want to accept, my or discuss the incident. I did start talking about some directives that really needed to be in place for, like, wear your vest, enter the front door because it's a matter of safety. It's a COVID protocol that you have to get a temperature check coming in, and carrying your go kit out, which is important. And when I really started talking about the incident, he got really defensive, and he did not want to accept. He said, "No, thank you. No, thank you. No, thank you." And it resulted in him walking out of the meeting.
During that meeting, what did he claim with regard to why the lights were off?
He told me that the power was out.
Had the power been out earlier that day?
Yes, the power was out earlier that day, and I had documented anytime there's a power outage or, and we take that as an emergency drill, so our crisis team moves into action. And I documented that it ended shortly after 2 o'clock, and I, filed a drill at 2:11.
And what time did this incident occur?
Shortly after 3 o'clock.
So you stated that he refused to answer your questions. Did he ever do anything during the meeting, or did he end the meeting?
Um, he just got really defensive and just, did not want to talk about the incident. And he did say, that the lights were on during the time. And I told him, no, the lights were off because I was the one who turned them on.
Did he walk out during your meeting?
He walked out of the meeting.
Had you ended the meeting at that point?
No.
Did anything happen after the meeting? And I'm talking about later on that day, that morning, actually.
I would say mid-morning, he came back into my office and I was, getting ready to get online to an IEP meeting, and he came in and very different demeanor. He said, I just came in to tell you that I will follow your directives. And I said, okay, but we still need to talk about the incident that happened in the classroom. And at that point, he got, again, very defensive and, accused me of singling him out, turned around, walked right back out. And then on the way out, I heard him say, now I feel suddenly ill.
Did you happen to visit his classroom later that day?
Yes, part of my duty is to do classroom walkthroughs. So I had been doing classroom walkthroughs earlier in the week and continued on. That afternoon, I went into his classroom and did a classroom walkthrough.
And what information are staff given regarding walkthroughs?
At the beginning of the school year, generally during orientation, talk about, a lot of the expectations, including classroom walkthroughs. The initial classroom walkthrough, generally happens where I just give a general notice, maybe a week before. I remember that particular initial, I sent out a notice in my staff bulletin on August 27th to let the staff know that, I started my classroom walkthroughs. These are the things I'm looking for, and that, was sent out to all staff.
And what is your standard protocol at the end of the walkthrough?
Generally, I like to leave a Post-it note on their monitor, which I also tell them I'm going to leave a Post-it note on your monitor. And, it just gives them direction to stop over and see me about your classroom walkthrough.
And did you do that with Mr. Marcia?
Yes. Did
he see you at the end of that school day?
Yes.
And what happened during that meeting?
I started to talk about, the data there. I talked about, the lack of student engagement. I talked about, I asked him about, where he usually is, teaching, how he teaches. I wanted to get an idea, which is all part of a discussion between a principal and a teacher with the hopes that I could help him. And he got really defensive.
Did he walk out of that meeting as well?
Yes, he did.
Did you ever meet with him again on September 7th?
I did.
Was his unit representative present?
Yes.
And was anyone present with you?
I believe Mr. Switch.
And were you able to discuss the drug incident on September 7th?
Yes.
And during that time, how did he respond?
He was somewhat argumentative. And I felt like he was very disrespectful and did not want to accept any directives that I felt are important for safety of students and the classroom learning.
Did he ever take any responsibility for not properly supervising the class?
No,
Did he ever take any responsibility for not observing the student or addressing the fact that she was smoking marijuana in his class?
no,
Did he ever take any responsibility for having the lights off in his classroom?
no.
What was Mr. Marcia doing when you entered the room on the day of the incident?
He was sitting at his desk and, I believe I'm assuming he was probably taking attendance because the seventh period just had started.
And what did you do with the information regarding this incident?
On that, morning of the 7th, I decided to contact my superiors, Assistant Superintendent, Ms. McNellis, and Margaret Kochek, because I felt like, he was not responsive to my directives or my help.
And what response did you receive when you contacted them?
I received, notice that he would be placed on administrative leave and an investigation would be conducted.
And did you meet with anybody concerning the investigation?
I met with David Griego, safety coordinator.
And after the investigation, there was a predetermination meeting with Mr. Marcia. Were you present for that?
Yes.
During that meeting, what did Mr. Marcia state about the drug incident in his classroom?
I don't know, I guess there was two things. He said that he said he wasn't aware that it was marijuana, but I know we did tell him that on the 2nd. We did tell him about that when Mr. Switch and I had met with him that morning.
And did he ever take any responsibility in the predetermination meeting for the incident?
No,
And with regard to teaching in the classroom, did you ever tell him to spend 100% of his time lecturing in front of the classroom?
no. What I had shared with him was that I wanted him to move about in the classroom to improve the student engagement.
Thank you. I don't have any further questions.
Are you ready for class?
Yes. Good afternoon, Dr. Mike. Did you request to be assigned to the middle school this year?
No,
Were you asked to be reassigned last year but resisted the year previous?
Objection, relevance, and goes beyond the scope of direct.
Mr. Maxey, what's your response to that?
Dr. Mike has a clear history of being in an elementary principal, and this was her first year at the middle school, and this was part of a redistribution of all administrators, in which all administrators had to reapply for their positions and then were assigned. This was Dr. Mike's first time to be a middle school principal, and I wanted to set that as foundational.
Mr. Maxey, there's one issue here, and that is whether or not the district can show that it had just cause to terminate Mr. and how do you say it now?
Marcia,
Marcia.
I would prefer that, oh, I'm sorry.
And are you going to say you would prefer being called Dr. Marcia?
Well, just for clarity, because it's on all the documents.
That's fine.
Okay.
Mr. Maxey, we're going to be very careful with respect to relevance in this matter. I do note that there are a number of things alleged in some of your client's exhibits that I think go beyond the scope of this proceeding. So if you want to establish something like that, you need to be very direct about it. I'm not going to give a whole lot of latitude on this issue. And so I'm going to actually uphold the objection. I'm going to ask you to restate your question.
Have you ever applied for a middle school position, Dr. Mike?
no.
Thank you. Has all your experience been at the elementary level?
Not all. I've been at the district level.
Can you tell us a little bit more about that day, the day in question? What do you remember? Was there an evacuation drill that morning?
We had our power outage, which was, that earlier that day. And we had, the incident that occurred, just after 3 o'clock, which was the 7th period that day. And as stated before, the aide caught me in the hallway, informed me. I went to the classroom, turned on the light. She pointed out 2 students. When I asked her, was there anybody who felt who saw or sitting by? Confirmed that after talking with the 2 students. And retrieved the paraphernalia and the marijuana and went to the office and talked with Mr. Switch at that point.
You also mentioned that, so it was a turbulent day. The kids had been held in the gym, is my understanding, during that time. They weren't in class. Is that correct?
No, some students may have been in there, but most students were in the classrooms.
Are your classrooms equipped with emergency lights?
I don't recall. We do have flashlights. Some classrooms, like Mr. Marcella's classroom, has windows.
But there were no emergency lights for the hallways in your school?
There are some located in different sections of the school.
Were you aware that Dr. Marcia had found kids wandering the hall and returned them to the gym?
No.
I apologize for interrupting. We have a board member that is wanting to join. So can you help me with that, Mr. Neville?
I apologize, I didn't hear what you said about a board member.
We have a board member, Ms. Asmus, who would like to join the hearing.
Oh, okay.
And I'm checking in with Mr. Noble on how she should do that.
Is my time suspended? Is my time being suspended during this time? Thank you,
I apologize.
appreciate that.
Mr. Noble?
Yeah. She has a question.
Yes,
Ms. Asmus would like to join the hearing. How do I help her do that?
with their audio system or her microphone. Is that what you're asking?
She's out of
Remote.
the district.
She's not in the district.
Mr. Noble, can you please email her some information?
I can.
Okay, thank you. Ready to go back, Mr. Maxey?
Okay.
My apologies.
Thank you. Dr. Mike, there are some things that are not clear in regards to sequence of events. In Dr. Marcia's class, my understanding is that an EA witnessed this event as she walked into the class. Is that correct?
I believe so.
Okay.
She supports students in there.
Did you escort the student to the office from the classroom, or did the EA already have the student with her and escorting her to the office when they made contact with you?
I partly did because it's a long hallway, and I told her carry on and walk the student to, so that way I could go back to the classroom and talk to the 2 students that she pointed out.
So did you immediately then go from the hallway to Dr. Marcias's class, or did you go first to the office?
I was at Mr. Marcia's classroom.
Okay. There's several things we'd like to reestablish When you first came on as staff member, do you remember receiving an email from Dr. Marcia in support and wanting to work with you for the betterment of the kids? Do you remember that email?
I don't recall.
Hearing officer, we had requested for the district to respond and provide emails. We discovered yesterday that there are several emails, including the witness's testimony today, that she had communication and received communication in regards to the Dr. Marcia being placed on administrative leave, which those emails, texts, or communications have not been provided to us. We'd like to enter some exhibits that are emails between Dr. Mike and Dr. Marcia that were not provided. They're positive in nature, and we believe that everything that has been provided from the district so far has been less than due process for Dr. Marcia. So we would like to enter some of these emails at this time.
Ms. Holcomb, what's your question?
So my first objection would be that these were obviously emails that would be in Dr. Marcia's possession. And if there was anything that they felt was not provided, that they should have brought that to our attention prior to this, as we've been providing documentation since we first received the request on November 30th.
May I respond?
Mr. Maxey, is that correct, that these came from Dr. Marcia?
These are between Dr. Marcia's and Dr. Mike. They were part of the request. It wasn't until yesterday that we discovered the district had not provided these when Dr. Marcia mentioned these. So we only knew about these emails as of yesterday.
I must admit, Mr. Maxey, I'm a little confused. If your client had them, I understand maybe there was a glitch there in getting those, but I do see the point made by Ms. Holcomb. And have you shared these exhibits with Ms. Holcomb?
We just brought them today, and frankly, the way in which this hearing has gotten started has been very unusual compared to how we normally deal with procedural matters. It's not.
Mr. Maxey, I asked you
May
a
I
question,
finish?
and I haven't heard an answer. When you learned of these exhibits and wanted to introduce them yesterday, did you send any email or otherwise notify opposing counsel?
No, because Dr. Marcia, not till late yesterday afternoon, said, well, wait a minute, I believe I've talked to Dr. Mike about that.
So my request is first that you show these exhibits to opposing counsel and see if she still has some infection.
Okay.
would still object to the first document is dated August 5th, so it predates the incident that we're here about today. The next document was a series of emails which were clearly provided by Dr. Marcia to his union representative at the time. And I believe these were actually provided in the emails that we provided to.
They are not, and Dr. Marcias has not had access to his computers. He only remembered these and was able to locate them late yesterday evening. I will withdraw the one from August 5th, but I think it's pertinent because the district had these. It's not incumbent upon the appellant when there is a motion to produce. The district has a requirement to produce both positive and negative. And so far, only thing that has been produced by the district has been negative. These were still in the email cache of the districts, yet they were not provided.
Mr. Maxey, I'm not gonna, we don't have a ton of time to belabor that point. What I'm interested in is making sure that both sides were adequately prepared and can be prepared. So I'm glad that you are withdrawing the email from August, and I think we would like to see a copy of that exhibit.
May I approach?
We certainly haven't, we didn't provide that to us either. No, you can hand it out.
Ms. Hookham, did you retain the copy?
No.
Ms. Holcomb, I'm going to overrule your objection and assuming that you can substantiate the exhibit through a witness, Mr. Maxey, you will vote for the exhibit.
I can through Dr. Marcia when it's during our time.
All right, well then I will hold that in abeyance that you can proceed.
Thank you. Shall I proceed?
Yes.
Thank you.
And what exhibit would you prefer this as?
Double A. AA. Dr. Mike, what's been designated as Exhibit AA that I just handed you, do these emails seem familiar to you?
Excuse me, before you go forward, I want to clarify, there is a document in which they requested the production of documents. The request was, please provide copies of all written or recorded communications between any of the district administrators regarding any issue related to Dr. Marcia. So this was not an email between administrators.
Ms. Holcomb, that's noted. Thank you. And as I indicated before, I was belabor the discovery.
Thank you.
Yes, ma'am.
Does this document seem familiar?
Yes.
These emails? Do you see what's dated September 2nd, 2021 at 11:15 a.m.? Do you mind to read that first sentence, please?
I am implementing the directive that you have suggested in your meeting.
At that time, did Dr. Marcia ever enter from the side door again or for the remainder of his tenure in your building before being placed on administrative leave? Did he abide by the directive to enter through the front?
I don't recall.
Okay. You also talked about safety protocols and a safety kit. Did you issue Dr. Marcia a safety kit and a safety vest?
My directions for all staff is for them to, get a bag, bring it from home so they're familiar with that, and to supply that. So at that time, my safety team had sent out suggestions on what can be in there, but the main thing was attendance. You know, make sure you take your attendance as part of that. And we did get vests for all staff as well.
And you had a bag for every staff member by the time this incident took place?
Yes.
Okay. Do you remember a PLC just the week before in which this incident, the safety bag and the safety vest was brought up by you in the PLC?
No.
Okay. Thank you. In regards to you coming in and saying you turned on the lights, do you mind to look at the district exhibit 4, please? Can you describe what exhibit 4 is, please?
It's Mr. Marcia's classroom and facing the door, the entrance door facing the east wall.
Do you notice how there's some lights on, some lights off?
Yes.
Clarification, say, Mr. Maxey, and the board's understanding, this exhibit has not yet been admitted, is that correct?
That's correct.
It's,
I'm just clarifying, Mr. Maxey. Are you wishing to make this exhibit your own?
I wish to enter this exhibit that is the district's exhibit.
No objection? Will that be used, Mr. Maxey?
No, we were using the district's witness book. Therefore, it's called Exhibit 4. That's normally, unless Ms. Holcomb has something else, that's normally, we make reference back and forth depending on which book is being used at the time. In fact, one of our procedural things that we had, Ms. Holcomb and I had discussed, is that we are going to use a report from a district employee from the district's book and not from our witness book. Am I correct on that, Ms. Holcomb?
That's correct. I had a concern, a FERPA concern, that they had not removed the student's name.
Thank you, Mr. Maxey. Lots of places do it differently, and I just wanted to make that clear for the record. So you're adopting Exhibit 4.
Yes, at this time, we have no objection to the district's exhibits.
Hearing that, would you like to proceed with just having adopted those?
Sure, I'll move for admission of all of the district's exhibits, which are exhibits 1 through 10.
And we'd like for the admission of all of our exhibits except Exhibit L and M.
And we have an objection to admission of their exhibits.
We're going to hold off on that, Mr. Maxey. You haven't started your case yet, so we're still in cross.
Dr. Mike, prior to this incident, had you had any other concerns about Dr. Marcia as an educator?
I think it was reported to me from Mr. Switch that he was not following emergency protocols. That was prior to the incident, yes. And that was being inconsistent with following protocols and entry of the building.
And he corrected that, is my question to you. To your knowledge, he corrected that once you brought that directive to him?
Objection asked and answered.
Same.
Okay. Let's go to the day of the meeting. The day of the meeting, when you brought Dr. Marcia in, and he came in to visit with you, did you tell him at that meeting that there had been marijuana found on the student's person?
I would object to the form of the question in as much as there are several days in which Dr. Mike testified about meeting with Mr. or Dr. Marcia, and I've asked that be clarified which day he's referring to.
Mr. Maxey, can you clarify the question, please?
I can clarify the question, thank you. What day did you finally notify Dr. Marcia that there had been marijuana found on the student's person?
The next day, September 2nd.
During that meeting on during that day of the incident that happened, and that meeting that you had with Dr. Marcia, was there a vape pen discussed?
Initially, I believe he thought it was. He stated that, that a student had a vape pen, and I corrected him and told him, no, it was a makeshift pipe with marijuana.
Did you or your assistant principal take a picture of that paraphernalia?
I apologize, it's because that's trying to.
Mr. May, date of that come to you, okay? So, is there a way to get a microphone on you?
For me?
Yes.
Is that on?
No, just a wireless mic, one that the lavaliers workers are using.
My apologies, Mr. Maxey.
Dr. Mike, do you mind to turn to Exhibit 2 in the book before you? May I approach so I can turn to the right page. Exhibit 2, and now social distancing. And if you'll turn over a few pages, you're going to see a handwritten statement by the EA. Do you want to review that just briefly? Dr. Mike, is it possible that in the turmoil of the day, with what had gone on with disruptions within the normal school day, which we can all as teachers agree with are always difficult, is it possible that the EA and Dr. Marcia may have mistook what had taken place in the room as being a vape pen versus drug paraphernalia or a makeshift pipe? Is that a reasonable understanding?
Objection relevance. The reason being is that either way, both are prohibited from being in the classroom or on a student.
Well, the key.
The door. Would you like to respond, Mr. Mackey?
I'd like to respond. The key to this is that the discharge notice indicates that Dr. Marcia was defensive and wasn't taking responsibility for the incident that happened in his classroom. As what had happened into his classroom, it may have been unclear to both he and the EA as to the seriousness of that. That goes to the relevance that it had been a rather distracting day, and the teacher and the EA were doing the best that they could with the incidents that had happened during the day and the turmoil that had taken place in the school.
So Mr. Maxey, I'm gonna note that I want you to be able to respond to the objection, but I want you to be careful about testifying when you do that. And so I'd like you to move forward with your question.
Okay.
I'm gonna overrule the objection.
I'll rephrase. In the EA statement, does she list a vape pen?
She does.
Thank you. Does she list any marijuana or anything of an illegal substance?
She lists smoke, exhaling smoke.
Okay. Thank you.
Apologize. I don't know when is a good time, but just walking into the setting, is there a way we can meet, just the board?
We have been in executive session. We can go back into executive session. We are in the middle of testimony right now, however.
I think it's very important, and I would like to meet with the board only.
second to adjourn to executive session? Mr. Martinez?
Yes.
Mr. Montoya, excuse me.
Yes.
Ms. Askey?
Yes.
Ms. George? Ms. Asmus?
Yes.
Myself, yes. We'll adjourn to executive session.
approach?
Yes, sir. Ms. Aspas, that's AA.
I need a motion and a second to reconvene in open session. Only the items discussed previously regarding executive session were discussed.
I motion to reconvene in open session.
Do I have a second? Mr. Montoya?
Yes.
Ms. George? Ms. Haskey?
Yes.
Ms. Asmus?
Yes.
Myself, yes. Ms. Chappelle, will you proceed?
Yes, sir. Mr. Massey, do you remember where we left?
Yes. Point of order, do you, I have that I've used 12 minutes. I'm just confirming that.
I had a little longer than that, Mr. Massey. I'm
Why,
gonna.
I know, I just want clarification on how many minutes have been used so far, if you don't mind.
Yes, sir. I had you at about 15 or 20 minutes.
15 or 20, because those
I
are
was,
big differences.
it was hard for me to keep track of both.
Okay.
So
I will agree to 15 minutes
So
then.
that's fine. We will
Okay.
have you down as 15 minutes.
Yes.
At this time, I'd like to conclude. Dr. Mike, when you entered on the day of the incident into Dr. Macias' class, was he instructing?
No.
Do you mind to tell me what he was doing?
He was at his computer, and I assume that he was taking attendance.
Okay. But he was carrying out the duties of a teacher.
At the first, yes, about when the period started, yes.
I'd like to go to September 2nd at your first meeting. Did you mention to Dr. Marcia that you considered him insubordinate or used the term insubordination?
When he kept saying no thank you to my directives and following safety protocols, I said, Mr. Marcia, it may be considered insubordination if you do not follow the directives.
Are you familiar with the collective bargaining agreement?
For the most part.
Are you aware that if a meeting either begins and leads towards discipline or is disciplinary in nature, the member is entitled to representation?
I am familiar with that.
Did Dr. Marcia ask to stop the meeting so he could have representation?
No, he walked out of the meeting.
Okay, no further questions.
Ms. Holcomb, do you have any redirect?
Yes, I do. Just a couple of questions. Dr. Mike, is a vape pen allowed in school?
No,
Can marijuana be smoked in a vape pen, to your knowledge?
I believe so.
Thank you. I don't have any further questions. I'd like to call Michael Switch to the stand.
Real quick, do you feel like you will need to call either one of you again, this witness, or can she be excused?
I don't need to recall her, and I'm sorry, I didn't ask if the board had any questions for Dr. Mike.
Correct, I'm
I
gonna
don't have
I'm
any
gonna get
further
to
questions
that.
for her.
I think because of the arbitrary capricious time limit that was set on this, we don't see a need at this time advantageous to recall her.
With that, I'm gonna turn it over to the board for any questions for this witness.
Dr. Knight, on the board?
I have a question. I can't hear what you're saying. Can you repeat what you said in answering the question?
I'm not sure which question. The last question?
I guess both questions that he asked.
Um,
I can't hear. I'm gonna go to you.
Mic maybe closer to you.
It is, the fans are kicked on in the back, board president, members of the board, and it is a little more difficult for me also to hear.
Would it be all right if she could pull her mask down? She gets, or if she doesn't mind.
Okay. Sure, thank you.
Mr. Maxey, do you mind restating the questions so that we can help the witness remember what the question was? And maybe that might be helpful.
Was Dr. Marcia performing duties of a teacher?
I think your question was when I walked into the classroom, and my answer was he was sitting at the computer. I assumed that he was taking attendance.
I would agree that that was the answer. Second question I had was on the September 2nd meeting. Did you raise the issue of insubordination with Dr. Marcia?
I answered that when Mr. Marcia responded, no thank you to my directives in following safety protocols, and he started to get up to walk out, that's when I said, Mr. Marcia, you know, if you do not follow my directives, this may look like insubordination.
Thank you, Dr. Mike.
I have a question, Mr. President.
Yes, Mr. Montoya.
Dr. Mike, was the substance ever tested to verify that it was marijuana? Or was there somebody with enough knowledge and experience to be able to justify that that's what it was for its validity?
The law enforcement did confirm that.
Further questions, board?
No further questions.
I do have another question.
Okay, all right.
Ms. Mike, with the understanding of your principalship and rules and regulations for CCSD and quite frankly the state of New Mexico, are you aware that at this time that the Navajo Nation deems it illegal?
I am aware, yes.
And also, does the state of New Mexico, to your knowledge,
Yes.
and the federal government, to your
Yes.
knowledge? Thank you.
Any other questions, board members? Any redirect counsel on the scope of that?
No, thank you.
Mr. Maxey?
No, thank you.
Dr. Mike, you are excused.
I have one.
Okay.
Go ahead.
Who do I ask, board president or?
Yes, go ahead.
So can you, I'm really coming into this and, so my questions might not be, might be ignorant, so. But, when, I guess the the legality of it is in the write-ups or the paperwork, the documentation, is the board policy copied in there? In that?
In the initial referral?
No,
Or-
or the.
Oh,
I guess
yeah.
your HR.
Yes.
report.
Yes.
Where is that? In this binder?
Ms. Aspas, that would be in the notice of intent to recommend discharge. The board policies are included in that.
Okay.
And we haven't gotten to that document yet.
Exhibit 5,
Okay.
and the policies are there as well. 7, 8, 9, and 10.
And I will be presenting those in a subsequent witness or witnesses.
Thank you.
You're welcome.
On exhibit 2, interview with Andrew Mike, it says that, or let me see, below that one, sorry. Did Dr. Mike, do you know if we had any interventions through the school district for this student for his drug issue, as the mother was aware of a drug issue and was very supportive of the discipline issued by the school? Do you know if we had any follow-up with that student for his addiction? I don't know.
So I'm going to give a little guidance, board members, that the issue we are here on today is whether or not the district has just cause on the termination.
Okay.
So I would
Okay.
concentrate on that issue.
Okay, so that would, may I have one more question? Okay, Dr. Mike, you followed the procedure for any staff member in the school district who is a mandated reporter, which would have been in the case, in the classroom with the situation that had taken place, correct? Or is that? Okay.
I'm sorry, Board President, Madam Secretary, can you repeat that again?
Yes, I was just asking if you followed the procedure for any staff member in the school district who is a first mandated reporter, if that process was followed with the staff, and if you were following that process.
Yes, that would be the educational aide who initially reported to me, and yes, we did follow protocol.
Thank you.
President, I have one more question. Thank you. Ms. Mike, according to the notice of intent to recommend discharge, under paragraph
2, Board Policy G-0761, GBEB-R, Staff Conduct. It states in Staff Conduct, employees are expected to exercise general supervision over the conduct of students not only while in the schoolroom, but also before and after school, during recess. All personnel employed by the district are expected to relate to students of the district in a manner that maintains social and moral patterns of behavior consistent with the community standards and acceptable professional conduct. In my question to you, that's exactly what you are standing to in regards to the notice intent of recommendation with the attended policy, correct?
Yes.
Thank you.
Any further questions, board members?
I have a question, Board President. So, am I allowed to ask, I guess not. That's okay, thank you.
Are there any other questions? Board President, I recommend that this witness be dismissed.
Madam Hearing officer, there was a window opened that I would like to redirect. Dr. Mike, are you aware of any other circumstances in which teachers have had students smoke in their classroom in which they were not discharged or disciplined?
Objection goes beyond the scope of direct and goes beyond the scope of any board members' questions.
That is correct, Mr. Menzies.
So her objection is sustained?
Her objection is sustained.
Okay, I withdraw.
May I ask one? So in the rules of civil procedure, the cross,
First of all, I want to hear an explanation from Nina. Why?
So I made the objection because this was my witness that I presented, and so I gave direct testimony from Dr. Mike. Mr. Maxey then does cross-examination, but his cross-examination is limited to the questions I asked her about, or in this case, any questions that the board asked her about. So the question that he was asking was beyond anything that I asked Dr. Mike about and anything beyond what the board asked her about. So by law, he's limited to what I asked her.
So may I ask that question?
I would still say it was beyond what she testified about, and that may be part of his presentation in the defense of Dr. Marcia. And then I think at that point, that information he can address.
board members, he will have his chance of his own direct testimony with his own witnesses.
No, I mean, I feel that the question is relevant, and so, especially to this matter, to this, if it's happening in other areas of the school, and I would think.
Board President, hearing officer, can we take a quick recess so council and I can visit? I ask leeway to acknowledge that we will be presenting that information in our direct to alleviate the board members' concern.
Thank you, Mr. Mency, and I understand you have an exhibit to that point as well.
Correct. It is, well, we'll go to if there's an objection to that, but.
So with no further questions, Board President and board members, I recommend that this witness be dismissed and we move on to the next witness.
Sorry.
Thank you, thank you, thank you, board.
Ms. Holcomb, I didn't hear who you were calling.
Michael Switch.
Oh, the assistant.
Mr. Switch, you're going to get sworn in by Ms. Chappelle before you start, since she's sitting up there next.
Hi, Mr. Switzer. Mr. Switch, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
I pass the witness to you, Ms. Holcomb.
Mr. Switch, there's a microphone there in front of you. I'm going to ask that you put it on, but also just speak loudly. We are having difficulty with fans going and masks on, making sure that the witnesses are heard. Can you please state your full name for the record?
Michael Dwight Switch.
And can you tell me what your position is with the district?
Assistant Principal, Athletic Coordinator at TVA Middle School.
And how many years have you been with the district?
Going on my 5th year,
And how many years have you been in education?
19.
Can you tell me how you first became aware of the incident involving Dr. Marcia on September 1st of 2021?
Yes, I was aware about the situation. I was in my office taking care of another situation, and at that time, that's when I was notified by Dr. Mike.
And did somebody bring a student to your office?
Yes, that was Miss Lee.
And is she the educational assistant?
That is correct.
And why was the student brought to your office?
It was brought to my attention at the time that this student had drug paraphernalia on her and had been smoking in the classroom.
And do you know who it was that actually identified the student as smoking in the classroom?
It was brought to my attention by Dr. Mike and Miss Lee.
But who actually observed it?
Miss Lee was the one that observed it.
And what happened while the student was in your office?
At first, she was very quiet, didn't want to say anything. But after talking to her, she did admit smoking in the classroom.
And did you ask her anything about that incident?
Yes, I did.
What did you ask?
At the end of our conversation, after I notified her parents and the proper procedure we have to follow through our school district is to notify the Navajo police of the situation. As I was waiting for her mother and father and the Navajo police, I just asked her, I said, this is the first that I've heard this. Why would you do it? And if you were going to do it, why didn't you leave the classroom? And she said to me, Mr. Switch, why leave? Because the teacher never pays attention.
Did the student admit that it was marijuana?
Yes.
And did law enforcement confirm it?
Yes.
What did you tell Ms. Lee about the incident?
Excuse me, could you repeat that, please?
Yes, what did you tell Ms. Lee about the incident?
At the time, I told her when I was doing my investigation with the student and talking to the parents and the police that before she leaves school grounds, she was going to have to give me a written report of what she saw took place in that classroom that day.
And did she?
Yes, she did.
Can you turn to Exhibit 1 in that binder for me, please? Do you recognize that document?
Yes, ma'am, I do.
Can you identify it?
Yes.
What is it?
It's the written statement that I requested in person to Miss Lee that I was going to need the documentation before she left that day of what happened.
And what time did she note at the top as the time that the incident occurred?
3:04.
Dr. Mike just testified and stated that she held a meeting with Dr. Marcia the next day on September 2nd regarding safety protocols and this incident. Were you present at that meeting?
Yes, ma'am, I was.
And can you tell me what occurred during that meeting?
At the meeting, I was there in the office that took place. It was all three of us. I know that Dr. Mike went over all the procedures of what took place, and she was trying to help James during this time. And as more into the conversation, the meeting, Mr. Marcellus was getting upset.
Objection.
What's your objection?
Objection is his name is not Marcellus. If he's the assistant principal, he should surely know his staff. It's Dr. Marcia.
Mr. Switch, can you go ahead and refer to him as Dr. Marcia?
Dr. Marcia, as I was sitting, observing, and paying attention in the meeting, Dr. Mike was going over all the things that transpire the day from the incident in the classroom. And the more that Dr. Mike was talking, Dr. Marcellus was getting upset.
Did he actually walk out of the meeting?
Yes, he did.
Was that before it was actually concluded?
Yes.
Were you also present for a subsequent meeting on September 7th?
Yes.
And what occurred during that meeting?
It's the same, it was the same behavior. I know that during this time, Dr. Mike was trying to help, and we were trying to work with him. And
Objection calls for supposition.
Actually, if he's just testifying, you can't object to testimony, you can object to questions. May I proceed?
That is correct, Mr. Maxey. And my understanding is he was at the meeting, he was testifying, he was there first person. Please continue.
Go ahead, Mr. Switch.
in my observation, the more we were trying to help him, the more frustrated, more that he was getting aggravated at Dr. Mike.
Did Dr. Marcia ever accept any responsibility for the incident?
No.
Were you interviewed as part of the investigation?
Yes.
And did you provide any documents as part of that investigation?
Yes, I did.
What did you provide?
I provided all the documentation that I was required to turn over from what I saw and from what I heard involving this incident.
Did that include Exhibit 1, Ms. Lee's statement?
That is correct.
And how about the major referral form for the student?
That is correct.
Did you have any other involvement in this matter?
Yes, I did. At the time, the plaintiff here, he was at the time he was being escorted off of school grounds. Me and the security guard walked him to his vehicle. I gave him directions of what he can and cannot do when it comes to picking up his daughter on school grounds. I gave him the exact location and where he needed to drop her off before school and after school. I've had direct contact since that time.
There wasn't a question asked on that point. Objection.
Actually, the question was, has he had any other involvement in this matter, and he's answering it. Go ahead, Mr. Switch. And again, can't object or interrupt the testimony, please.
And can I say this?
So hold on a second.
Withdrawn.
Thank you, Mr. Maxey. You haven't interrupted the witnesses before, so I'm going to ask you not to interrupt, sir.
Go ahead, Mr. Switch.
It was given through our office, our administration team at TBA school, that the plaintiff here could not be on school grounds. I personally had to, not once, not twice, ask the gentleman to leave school grounds. At one time, and I understand that he did call, but he did come in the school building, and I had to politely ask him, "Sir, you're going to have to leave." And he was there to check out his daughter. Daughter was sick. But yes, we were in the process of getting her daughter. And I asked him politely, "Okay, we'll take care of it." And he kind of got an attitude with me.
And is it typical that when folks, in your experience, when folks are placed on paid administrative leave, that they are not permitted onto school grounds?
That is correct.
Thank you. I don't have any further questions.
And I will say that he was also told, I understand.
I apologize, but she already went down.
Okay, all right.
So, Mr. Maxey, would you like to call?
Please. Have you ever been in Dr. Marcius's class
Just a couple times, yes.
prior to the incident?
Yes, but it was involved of getting another student in that matter, making
Were
sure.
there any issues you had during that time in regards to his conduct in the
I
classroom?
can't recall that.
Okay.
Mr. Switch, I'm just gonna advise you to let him finish his question. But we are recording this and it might be difficult for the reporter later to hear that. So, Mr. Maxey, please continue.
In the process of your investigation, did you ask Dr. Marcia for a statement?
No, sir.
But you asked Ms. Lee for a statement?
Can you repeat the question, please?
But you asked Ms. Lee for a statement?
Yes, I did.
Can you tell us why you didn't ask Dr. Marcia for a statement as a staff member?
At the time of the situation that was going on, I was just following the directions by my boss of what to do.
Have you ever been trained on how to conduct an investigation?
Yes, I have.
Can you tell us a little bit about that training?
It's been a little bit for a while, but I was always informed to make sure that I follow the proper chain of command.
Did you take a picture of the contraband?
Yes, I did.
Did you provide that to the officer, Mr. Griego?
Yes, I did.
Okay. Do you mind to turn to exhibit 2?
Yes.
Do you mind to thumb through there? There's several pages. Tell me when you get to that picture that you took and provided to Mr. Griego. Is the picture there?
I don't see it there, sir.
Thank you. Are you aware of what custodial interference is?
I do not.
Are you aware that Dr. Marcia has a child that is a student at TBI?
Yes, I am. Was
that student sick?
On which day, sir?
On the days after this
There was
incident?
a day that she was sick. Yes, it was brought to my attention. She was being checked out.
Okay. When you say that you pointed out to Dr. Marcia where he was to drop off and send his child, why was the child being punished and separated and segregated?
I was just following the directions that was given to me.
No further questions.
No redirect. Board members, do you have any questions of this witness?
Are there any questions? Go ahead.
So you were following directions, whose direction?
I was following the directions that went the day that the plaintiff here was asked to leave, that we were given from the main office of where the plaintiff was supposed to pick up his kid, pick up her daughter, and drop her off the daughter.
So does the main office have a name? Whose direction, whose directive?
It was communicated from the main office down to Dr. Mike, gave to me. The HR.
So HR and then to Mike and then to you?
Yes.
No.
Mr. Switch, you stated that the student who is the daughter of Dr. Macias, When she was sick, was she in the health office at that time? Do you recall?
I don't recall because there was another incident that took place at that time, and I was taking care of that situation which involved an athletic team, and I was trying to take care of that situation.
Okay, thank you.
Go ahead, Ms. Hatcher.
So, when the student was ailing, was she still being dropped off at this designated place?
I don't know, I don't know as far as where she was dropped off that morning, but I do know that in several mornings when I was out doing duty, that yes, she would be dropped off at this area and be picked up at the area that I informed the plaintiff. Yes.
I have another question.
Go ahead, Ms. George.
Mr. Switch, can you be a little bit more clear when you said that you took direction from the main or the front off from the office that you stated? Can you be more specific with your chain of command?
So the day that that the plaintiff here was informed from the HR to Dr. Mike, and then I was informed by Dr. Mike of the directions, the information I was supposed to tell the plaintiff about transportation for her daughter, where to be dropped off during the mornings, and also picked up after school, and she was also involved in athletics of where she needed to be picked up.
So, Mr. Switch, at any time do you recall the safety coordinator being involved in these decisions with HR regarding the student's safety, from pickup, drop-off, to picking up after school activities for the safety of that student, and when she was sick and being released to the custodial parent?
I don't recall.
Board members, any other questions? Ms. Atkins?
Okay, with that type of arrangement, is that part of the policy? Specifically under, titled under, this administrative that's placed on admin leave and their student, regarding their student, is there a policy such as that?
I don't recall. I mean,
Any other questions, board members?
Yes, please. Mr. Switch, can you please clarify where the location is that Dr. Marcia was to pick up and drop off his daughter?
it's on there's a side street there at TBA, and there's the interest that parents or guardians drop off their son or daughter. There's a gate out there, and then on the outside of that gate, that's where the plaintiff here would drop off his daughter and pick up his daughter if it was after school or after athletic event.
And are there other people coming through that gate as well?
Is when you say other, it's
Does anybody else come through that gate, or
Yeah.
is this out by itself?
I didn't hear your objection, Mr.
Leading,
I'll rephrase. Who else comes through that gate?
parents, students.
And I got a little confused by your testimony. You were asked about if the student was dropped off at the designated place when she was ailing, and you responded, "I don't know about that morning." But you then went into talking about other days when you were doing duty. And you were asked again about while the student was sick, and at that point you said yes. So I'm confused. Can you clarify your testimony for me?
Yes, I mean, on that day that she was sick, there was also incident that I as an administrator had to take care of. And I asked the plaintiff here to politely leave, and she did come to the front. And I don't know where the plaintiff went as far as meeting his daughter. I would think where he was supposed to pick her up was the designated spot that he'd been told several times of where to pick up his daughter.
And so was the daughter taken out to that spot or sent out?
She walked out the front doors.
Thank you. I don't have any further questions.
I have one. Is there someone assigned to, someone on staff assigned to watch that gate and to ensure student safety?
The people that are on staff on that duty at that time, during the mornings and afternoons, we are all assigned, everybody's assigned to look at that.
Someone is assigned at that location?
No one's assigned to that certain
Someone's
location.
assigned that. Thank you.
May I follow that up? You were just cut off during your response. Can you please complete your thought? You were talking about duty.
Is there a question?
Yes, I've asked him to complete
You
his
guys
thought.
crossed each other and he wasn't, he's in the middle of finishing his question, his answer.
So Mr. Switch, can you please complete your thought about duty?
So during duty, there's not one assigned person. We as a teaching staff and administration staff are assigned to that front area. There's no certain person assigned to that gate.
Would the front area include the gate?
Yes.
Thank you. I don't have anything further.
To be clear, Dr. Marcia was prevented from dropping his daughter off safely like all other parents through the drive-through. Is that correct?
Can you repeat the question?
Dr. Marcia was prevented from safely dropping off his daughter like all the other parents through the appropriate approved on-school ground drop-off area.
Objection, argumentative.
I think it goes to fact.
You just need to restate your question as a question.
Okay. Dr. Marcia was not allowed to drop his daughter off as other students were dropped off by their parents, correct?
I don't have an answer for that.
Okay. No further.
Are there any other questions of these witnesses?
Not necessarily. In this binder or anywhere, is there a map of the school?
No, there is not.
Is it possible to get one?
If I may, in a redirect, may I have that leeway?
You're not
Are you
on
going to
direct?
address Ms. Haas's question?
Yes.
Okay.
Dr. Marcia was not allowed to drop his daughter off on school grounds,
Mr. Marcy.
correct?
The question is asked is for a map, so we need to limit it to that.
Well, in these types of hearings, there is some leniency given, and I don't believe that leniency. The question is regarding a map. If we don't have a map, I think it's clear that we can indicate either that drop-off point was on school property or was off of school property.
So the first order of business, Mr. Maxey, and I hear where you're going. What I'm first wanting to do is make sure that this board member gets her question answered. The answer to that question, Ms. Aspis, is right now, no, we do not have a map. Where I think Mr. Maxey is going is potentially to try to give some understanding, because I think what you're wanting to know is how far away are we talking? What is the situation?
Well, I want to know, I mean, what has been stated, and I think that would have been relevant and important to show. I mean, we got pictures of a classroom and a trash can, and so I think that the map of the school showing the main entrances, or so that we get an idea of the entrances or the designated points that are being talked about.
Board members, Ms. Aspis, I do want to clarify a general thought on relevancy. The issue before the board is whether or not the district has just cause to terminate the employee. The questions about where the employee picked up his daughter while he was on admin leave don't quite go to that determination. I'm not saying we don't get to ask that, but I just wanted to put some bookends on relevancy and caution.
I wouldn't pursue that, because had I just seen Mr. Maxey say or question that, but I've also heard this side question, so that's why I'm saying.
I understand.
And I think if the board really wants to understand, that would have been an important piece of.
Ms. Aspis, I'm not disagreeing with your question. I just wanted to balance that a little bit. And so I'm going to ask perhaps if the two council can defer off to the side on how potentially to help this board understand the locational issues. If you wouldn't mind, that would be helpful.
My suggestion would be we can certainly get a map for the board to see the setup. I also agree it's not relevant. It may be part of Mr. Maxey's case, but in any event, we'd be happy to get a copy of a map.
I would like to point out, well, first of all, have you finished, Ms. Holcomb? I don't want to interrupt you.
Yes.
Thank you. I would like to point out that it is the testimony that was derived from the administration that again attempts, while it may be outside of the discharge, they opened the window and used it as a preponderance of Dr. Marcia's behavior, which is what they're attempting to establish.
Mr. Maxey, just so you know, I'm not arguing that point. I've allowed it, obviously.
Right.
And we both have had adequate time to develop that concept. So there has been absolutely no parameters put on that concept. I was just wanting to help the board understand the issues.
Thank you. I was pointing out only this wasn't our witness. We didn't open the window.
And there was not that assertion on the table, Mr.
Okay, thank you.
Mr. Switch, at any time do you recall yourself or your supervisor in the building, do you recall at any point from the district office, was there any question as to why Mr. Marcia did not have a written document about his statement as to what happened in the classroom, the time of events, and all of that, but the educational aide was asked to provide her side of the documentation of what occurred.
I was not aware.
Okay, thank you.
No, thank you.
Are we ready to excuse this witness?
Yes.
He's on our witness list. I would reserve the right to recall.
Okay.
Just a moment. If you would like to call him as a witness, he should have served him with a subpoena. So I would have an objection to that.
Well, actually, we issued a subpoena for several witnesses.
You can't actually issue the subpoenas. The board has to issue the subpoenas.
That's correct. We asked the board to issue those subpoenas. And the document last Friday, it's part of the record.
I didn't receive any request for issuance of any subpoenas.
I also didn't see the issuance of the subpoena, but in the spirit of trying to get to the truth and giving you all folks the ability to prove your case, I would recommend to the board that Mr. Switch continue staying around in case he is needed for rebuttal.
To that conversation, why doesn't the board know who was subpoenaed? I don't know how you say that plural, but
I didn't receive any notice of
but in general, you would know, or?
Sure, yes.
Okay,
Copy would be included.
okay.
If the board ultimately has the ability to issue the subpoena, so it should have come to the board.
And just for the record, I would object to having Mr. Switch have to remain available. We tried to address these issues before the hearing. I suggested that we have a deadline of last Tuesday for requesting subpoenas from the board. And Mr. Maxey or Ms. Krakowska, I'm not sure which one, objected to that deadline. So we had no established deadline. However,
No.
there was no request for subpoenas that was ever sent. And so the witnesses would have to be served with a subpoena, which includes a witness fee, and that has not been done. So none of my witnesses prepared to be staying beyond their required testimony on direct.
We vehemently disagree with Ms. Holcomb. We only objected to a deadline for filing of motions. That was the only objection that we raised, because it has not been clear to us who was going to be the hearing officer up until today. Second, when we sent our email saying these are our witnesses, we requested for them to be subpoenaed in our email request. I apologize, I don't have it, but we can sure bring that up on our emails. We've never encountered this problem before with any other previous hearing. When we have submitted our witness list, the hearing officer or the authority, being the board president, having had that transmitted to him by the board's attorney, has always made sure that those, especially those that are on staff, be present. I believe this is another indication of a denial of due process that has been evident today in regards to Dr. Marcia. So our only objection was to a deadline for motions. And I believe our email is clear in that.
If their only objection was the deadline to motions, then the deadline for requesting subpoenas was last Tuesday. I did not receive any request for subpoenas. I did receive a witness list. The witness list did not include any request for subpoenas. In any event, it would have been untimely. A request for subpoenas actually has to have the subpoena form laid out with each employee's name or each individual, each witness that's going to be called, with their name, their address, the date, the time, the location that they have to be available. Again, served upon either Ms. Chappelle or the board president, as we agreed. It would then have to be issued by Ms. Chappelle or the board president. It would then have to be sent back to Mr. Maxey and Ms. Krakowska to then be individually served on each one of those witnesses, along with a witness fee, a check or a witness fee. None of that occurred.
I would agree with Ms. Holcomb. Had we received the normal notification of a hearing and the designation of a hearing officer, that has never been sent and provided to the parties. In fact, became a contentious point between Ms. Krakowski and myself and counsel for the district. That delegation never happened, nor that notice ever happened.
Let's clarify a few things. The notice of the hearing was certainly sent out. The question of the board appointing a hearing examiner was not sent out as, at least as I've seen in the past, that's done at the hearing after a motion and a vote. Regardless of these issues, my question, Mr. Maxey, for you is, what other questions do you have of this witness? And what is the reason for needing to make him a direct instead of a witness on cross?
Well, first of all, it would depend on time, which has been severely limited. Second, I vehemently disagree with parts of accuracy that you have presented. But at this point, to move the hearing forward, because we already have, I think, a determination to move to arbitration in regards to the due process of Dr. Marcia, we'll release the witness so that we can move this forward so that the board can move to their other business, which is fast approaching us. So I release that, and again, note for the record that there has been a total lack of supporting the rights of due process for Dr. Marcia.
Mr. Maxey, my questions were meant to give you that leeway.
I release the witness, ma'am.
Again, Mr. Maxey, I need a direct answer here. What other questions do you need to elicit from this witness to support your position on your...
Hearing officer, members of the board, board president, we are releasing this witness from further testimony.
All right, so the record reflects that Mr. Maxey was given the opportunity to be able to further question this witness. That previous to the back and forth between opposing counsel, I had already recommended to the board that this witness be allowed to stay for further questioning, and that at this point, Mr. Maxey is withdrawing his request to make Mr. Switch his witness. Is that correct?
I only agree that we are withdrawing having Mr. Switch stay as a witness.
Mr. Switch and board members, at this point, my recommendation is to release the witness.
Thank you, Mr. Switch.
Yes. So, as I hear Mr. Maxey saying witnesses with an S, and we're just talking about Ms. Chappelle, where you're only talking about the interview of, or the continuation of Mr. Switch. What about the other witnesses? I mean, it sounds like your statement is trying to be fair, but when you hear witnesses,
Thank you, Ms. Estes. We're only in the district's case right now. And the appellant will have his opportunity to call all the witnesses that they have listed. The question here was whether or not they planned to call Mr. Switch as part of their witness list. And so that's what I was trying to do, was to ascertain whether or not there was additional information needing to be elicited from Mr. Switch, in the hopes that we could be efficient with how we're conducting the hearing.
May I ask you to dump that down? As far as appellate and.
Appellant is Dr. Marcia, and the administration obviously is still in the portion of the hearing where they are trying to make their case about the just cause for firing. And after they rest their case, Ms. Aspis, then the union representatives with Dr. Marcella, or former Dr. Marcella, will be able to put on their case to show why they don't think the district met their burden. So yes, they have their entire witness list to go through.
Point of clarification. On behalf of Dr. Marcia, are we understanding that neither the superintendent nor the district's council notified the witnesses that we requested to be here on our witness list that was submitted on Friday, as agreed to by the parties?
I'm not sure I understand the question, but.
I didn't address it to you. I addressed
Oh, I
it to
thought
the
you asked about
council and
administration.
to the board or to the superintendent. We submitted a
I'm
list.
representing the superintendent, so I'm answering on behalf of the superintendent.
Okay, so you're, okay, my apologies.
So again, we did not receive any subpoenas on behalf of any of the district's employees for me to notify them that they had to be here as witnesses for Mr. Maxey.
Was the subpoena form provided to the union?
Subpoena form is readily available as.
I'm not an attorney.
That's not my, that's not my issue.
I'm not an attorney, and this is why we have those.
And Mr. Maxey, you
instruments
just acknowledged that you agreed to the deadline of last Tuesday, that the only objection to that deadline was the motions. So as of last Tuesday, I did not receive anything asking for any district employees to be here.
I didn't agree that was the end of it. Can we take a recess and?
I'm going to interject for a second, Mr. Maxey. I have recommended to the board that you be allowed to ask this witness the questions you need to ask it. Are you still saying that you do not?
No, I'm not asking about this. I'm asking about our witnesses, Ms. Lee, Dr. Marcia's former principal, Ms. Gallagher, my apologies.
So that is not the district's responsibility, but those are your witnesses.
It is the hearing officer's responsibility as it normally has been in the past.
No, sir.
So the question that I have is, neither the superintendent nor the district's council have provided for those witnesses to be here today, though we listed them Friday.
That is your responsibility. That is not the district's responsibility.
That has never been my responsibility in a prior hearing before today.
In 20 years of practice, I've never heard.
Have you practiced 20 years in front of school boards versus other boards?
I've practiced 20 years in front of numerous boards, and they all utilize the rules of civil procedure to some varying degree. It's not very different, Mr. Maxey. And I wouldn't mind hearing from your opposing counsel as to the process as well. But my understanding is absolutely not. If you call a witness, it is your responsibility to subpoena and make sure that witness is there.
I believe my question is answered. Again, Dr. Marcia was placed at a disadvantage.
That's
by,
in your own hand. Would you like to respond?
I would just like to proceed on presenting my case.
Any room for questions?
On this back and forth? Sure.
So I'm getting confused here. Ms. Holcomb, you explained the process of how the witnesses are established or how that, and from what I gather, you said they make their requests to you?
No, so any witnesses that I call, I would have to, if they're district employees, obviously, I can get them here. But for example, if I wanted to call Mr. Marcia or Dr. Marcia as one of my witnesses, I would have had to, and they asked for this process, they asked for a subpoena process, so they asked to follow the civil procedure rules. Those are typically relaxed in these proceedings, but they asked for it to be more formalized. So when we agreed, or I suggested a timeline of a week before, because it does take some time. One, a request would have to go to Ms. Chappelle with the subpoena form filled out for her to complete or to bring to the president to sign off on, and then bring it back to me. And then I would then have to serve it on Dr. Marcia or his representative, along with a check saying, you need to be here at this time, at this location to testify for the administration.
Okay, so where I'm getting, I guess, mixed is when Mr. Maxey was starting to say to Chappelle, but then you said I'm the superintendent's lawyer. So that's where I thought the request goes to you, and then it comes back over here where.
So no, I would start off asking for the subpoena to be issued by the board or the board's attorney. And then had it been district employees, I would have accepted the subpoenas on behalf of the district, of the administration, if he had asked to do that. But I didn't get any subpoenas from Mr. Maxey or Ms. Krakowska. And I don't believe any requests for subpoenas, because I wasn't copied. I would have to actually be copied on an email to Ms. Chappelle stating we are requesting the subpoenas that are attached, and they would be filled out with each person's name to serve it on. And then those might be district employees, those might be some non-employees. The non-employees, obviously, I could not accept those subpoenas.
if I may,
Actually, Mr. Maxey.
I'm asking the board member, if I may.
Go ahead.
Thank you. These are quasi-judicial hearings. You can be represented by an attorney or by a member in the good standing of which we're a union representative. It has been our experience in which became a contentious issue is that we asked who was the board hearing officer. Until today, that was not established. It has been normal procedure that that is established weeks prior to the notice. We usually get 2 to 3 pages of documentation, which include whatever that hearing officer is wanting as far as submissions and deadlines and things like that. We have not received that. We did not agree to a motion deadline because we wanted to make an oral motion, of which we've not had opportunity to do today, for dismissal. We're not legal scholars, and we're not members of the bar. Therefore, in these hearings, we're usually accorded some deference so that we can ensure, because the number one thing is someone's due process rights and personal property rights and 14th Amendment rights are being challenged. And there has not been the normal procedures in this hearing that have been in every other hearing that we as union representatives have been involved in.
And your question is?
My question was, we never had a hearing officer designated until today to actually have the authority to do those things that in the past would be normally allocated to us. I was answering her question of, why hasn't this happened?
And did you make inquiry as to who that officer was?
Absolutely.
To whom?
We made it to Ms. Chappelle's. Who is the hearing officer and where are the notices for hearing and where are the rules for the hearing and the procedures that are going to be for the hearing? Normally those are 2 to 3 pages.
Mr. Maxey, that is not an accurate statement of our conversation.
Actually it is, because you and I had a difficult conversation.
You're speaking over me, sir. In our conversation, I indicated that I would be designated as the person helping the board through the process of the hearing. I did send out a series of emails requesting back and forth conversation between both parties on the subject matter you're discussing. Right now, it is 4:45 board members. We do have a designation on our agenda that the regular school board meeting will take place after the conclusion of this hearing. However, it is clear to me that Mr. Maxey does not have all of his witnesses present, and I don't think that this hearing can proceed because of that. So regardless of what the issues were leading up to this, it is important for Mr. Maxey to be able to have those witnesses present. And it is true that the rules of civil procedure are relaxed in this case. We are discussing the potential of an employee to lose their job, to be terminated. And so I do think that if there are witnesses that have not been called or are not, have not been essentially, I have to say, Mr. Maxey, in 20 years, I've never had a party not have made sure their witnesses were coming to a hearing. And so that is alarming to me, but I would like to request a recommendation to go into executive session because I do need to discuss some attorney-client evaluation, and I would like to make a recommendation.
I have 2 questions, if I may, Mr. Waltz.
Mr.
So, correct me if I'm wrong, but we have a district employee whose extended business day job is right now after 4:45. Does he get any compensation for that, or does that just fall under his other obligations during a hearing? Because right now his day ended at 4 or 4:30.
Yeah, the salaried employee, this day has just continued on.
Okay, and then second, the hearing officer, who, as of today, you say you didn't know who the hearing officer was. Can you state that for the record? Who the hearing officer was that you?
Motion made at 1:11 when you came into session, and the board designated Ms. Chappelle as the hearing officer. And up until that point, we had requested who the hearing officer was. And can you help me with that date? You were on that phone call. That was 2 weeks ago?
I think so.
Roughly, approximately 2 weeks ago. We can get the exact details, because I was concerned because we had already had to reschedule this hearing once because the notice did not come out timely within the statute. In fact, the notice for this hearing, we relented. We could have objected to it because it didn't come out timely, but we relented to move the process forward. And even as of today, because we didn't get a chance to argue for timeliness, which I believe Ms. Holcomb even expressed to me concerns about that it was only 1 hour each. We didn't get a chance to argue that because we didn't have a hearing officer that we could argue that motion before, as well as our motion to dismiss. But we've gone along with this process even after we've made written concern about the notice of discharge for the sake of Dr. Marcia. and to protect his due process rights, which include the right to moving into arbitration. People, as far as this witness goes, I feel for you. He's dismissed. We're willing to shorten our need for witnesses so that we can at least get Dr. Marcia to speak on his own behalf, but we're running out of that time, so I stop.
And is this a practice for both council and and both representatives here? So it was stated that the superintendent has his counsel here, Ms. Chappelle is the board's representative here, but both of you as a union rep, and I'm sorry, I didn't catch what you work for the state?
I'm a USERV director like Eva. I'm a colleague of Eva's.
Okay, but you guys are not counsel, you guys don't have a doctorate degree. Is this normal practice to where you're going against two councils, but you yourself defending an employee, you guys don't have a counsel to go against, so to say, go against the two councils provided by the district here?
I've never had an issue like today that we're having today. Never in 12 years. Never have I ever had this. Because the hearing officer has been noted weeks before, and we've already been doing these type of bickering things, and they've been ruled on by the hearing officer.
Thank you.
May I respond to that question? That would be their choice to proceed without an attorney here. NEA does have counsel that they call in on certain cases. I don't know why they chose not to in this case.
Mr. President? Comment? Question? In regards to that, Ms. Holcomb, I appreciate the fact that you said.
Obviously, within the confines of what you're talking about here, and obviously what people are perceiving to see, and what you've stated is making the comment the first time in 12 years. And again, Doctor, I'm not being disrespectful to the situation, but it would, and again, as Ms. Holcomb has stated, it's their decision and their choice, and I don't certainly mean that to demean either one of you, because I know you both have experience. But again, it's just, in my mind, rolling around that it would seem that the individual would need a lawyer. Again, that's just kind of speaking out loud as a question in respects to what we're bantering about back and forth right now.
I didn't hear a question, so I don't want to be rude and not answer a question. I mean, I appreciate your statement, and I take note of it. But if I missed a question, I apologize, Mr. Montoya.
I'm just having a little difficulty.
Going back and forth and almost kind of getting to the point where we're going in circles in respects to what it is, and I understand your point of what you're saying in regards to the situation. And again, as is pointed out by Ms. Holcomb, in respects to the choice of the representation. That's basically where I'm coming from. As a question of
representation for your claim.
So I'm gonna,
I have another question.
okay, do you want to respond to something like that? Okay, thank you. The spirit under the law of this process is to make sure that the board has appropriate and enough information to make a very good decision on this, particularly because it is involving termination of an employee. And so I do feel like I need to share some analysis with the board in executive session along those lines. And then we can come out and depending on what you all decide with respect to what I want to provide with you all, if you would allow that board, I think it would be helpful. I think right now we're kind of spinning wheels on a point that we have addressed and that has been discussed back and forth. But I do think it's important to press pause at this point.
And can we release the witness? Because I agree. It's
They go.
Thank you, Mr. Switch.
I have no objection.
Mr. Switch, thank you. Yes, go ahead.
So, earlier, I wish we could have played back what you said. And I can't even remember, but it seemed to me that, I guess they used Ms. Holcomb for leading the board. And whereas, coming into this, we are all told that it's really our decision as a board. And so I just want to, and I can't specifically say what part because I didn't want to be rude and cut off Cheryl, so, but it has been stated, Ms. Holcomb and Mr. Maxey, that the notice was, that this was scheduled for Tuesday or something like that. And then, now it's today. What did you mean by that?
The Tuesday reference was actually the suggestion I gave for subpoenas, for the deadline for subpoenas.
So I'm talking specifically about the notice.
The notice of hearing, so originally we were scheduled for February 1st.
Okay.
And Ms. Krakowska stated that there wasn't sufficient notice provided of the hearing and that they wanted a different date, and this was one of the dates that they proposed.
So that insufficient time was on us?
Yes.
So we dropped the ball on that part of it?
Yes, but you rescheduled to a date requested by Dr. Marcia's representatives. So we actually accommodated their request for a later date.
But there was a statutory requirement to hit that accommodation. And even the notice for today was a day late. And we could have objected then also because it was procedurally outside the timeline. But to move the hearing forward, we agreed to this date.
Okay, and then we keep referring to time, you know, as far as when this was scheduled, everybody knows since I don't know when that we have a regular board meeting and then this is scheduled in with the same date. So to go back and say that we have a board meeting at 4:30, that should have been kept in mind when this was scheduled. It shouldn't have been the very day. I feel like, you know, I was accused of stringing this along or whatever earlier, but to me, if that we had really wanted a good hearing, where, you know, time is not a factor, then we would have had this on a different date than a regular board meeting.
With that, board members, I do have some attorney-client privilege information I will be able to share.
Mr. Montoya?
Yes.
Mr. Montoya? Ms. Asmus?
Yes.
Thank you. Thank you for covering for me. I would like to entertain a motion and second to reconvene in open session. Only the items discussed previously regarding executive session were discussed in the executive session.
I motion to reconvene.
Brother Montoya. Gary.
Yes.
Ms. Haskey.
Yes.
Ms. George.
Yes.
Ms. Asmus.
Yes.
Myself, yes. I would like to entertain the following motion. In order to make every accommodation regarding due process, this hearing will be continued to another day agreeable to the parties and to provide appellant 5 business days to arrange his witnesses via a subpoena by February the 23rd, 2022. As part of that motion, parties will provide their availability on the same date. A hearing officer will be appointed at the time the continuation hearing is set and noticed. Upon continuation of the hearing, the district will resume with its witnesses.
Thank you so much for that. I was wondering, can we?
Mr. Maxey, they're voting right now.
Pardon me?
There's a vote, they need to do a motion and a second and vote.
Oh, my apologies.
I want a motion. I'll second that.
Ms. Asmus,
Yes.
Ms. Haskey,
Yes.
Ms. George, Mr. Montoya,
Yes.
myself, yes.
Thank you, Board President. I apologize. On behalf of Dr. Marcia, we appreciate that. Can we get that notice in writing? I was writing quickly, but if we could have council provide that so that we can meet those timelines, I would appreciate that. Thank you.
That will be available.
Can I make a comment? Can I make a comment?
Yes.
I think Mr. Montoya.
Mr. President, I'd like to make a comment.
Go ahead.
I would respectfully ask that both parties use this time very judiciously to get their witnesses in order to be able to present all the viable information to the board so they make a sound and reasonable determination on this matter. Thank you.
Any other comment from the audience? The participants, or whatever you're called. No, we reconvene our regular.
So adjourn. Motion to adjourn the due process hearing.
Can I have a motion to adjourn the due process hearing? And a second?
I motion to adjourn.
Do I have a second?
Second.
Been moved and seconded that we adjourn.
And vote.
Mr. Montoya, how do you vote?
Yes.
Ms. George?
Yes.
Ms. Haskey?
Yes.
Ms. Asmus?
Yes.
And myself, yes.
Do you want us to relinquish these?
This meeting,
That was my question.
and they collect it.
Okay.
I think we should collect it.
That's why I asked the question.
Ms.